48 hours before his grand opening, with 11 luxury cabins fully booked, a ribbon-cutting ceremony scheduled, and $2.5 million sunk into the ground, the fire marshal showed up, read a sign, made a phone call, and drove away. The whole thing collapsed, not because of a lawsuit, not because of a courtroom battle, but because of a gravel road. My gravel road. The one my grandfather staked into the ground in 1961 with a bucket of red paint and a concrete footing. And here's the part that still gets me. Nobody ever thought to check whose name was on it. This is that story. My grandfather Chester was not the kind of man who made big, flashy moves. He was the kind of man who read the fine print when everyone else was skimming. In 1961, he drove out to Kellerton County, Tennessee, looked at 34 acres of pine-covered land sitting along the edge of Clearwater Lake, and wrote a check for $12,000. Not because he was rolling in money, because he understood something that most people around him were too busy to notice. That quiet private land near water would be worth more someday than any number you could put on it that afternoon. He was right about the land. But what turned out to matter even more was something nobody paid attention to at the time. It was in the deed, just sitting there in that dry, bureaucratic language that makes most people's eyes glaze over. A private gravel road, 6 meters wide, just over a kilometer long, running straight from County Road 7 into the heart of the property. And right there in plain language, private road, no public easement recorded. Chester drove a wooden stake into the ground at the road's entrance that same year, poured a small concrete base around it, painted it red, and had the property designation stamped right into the surface. M441, Mercer Private Road. Over the decades, the paint faded from red to a dull rust. The lettering wore smooth at the edges. Weeds grew up around the base every spring, and nobody pulled them. That old stake just stood there at the corner of County Road 7, patient and unnoticed, the way old markers do when they have nothing left to announce and everything left to prove. I inherited the full 34 acres in 2009 after my father passed. By that point, I had spent 20 years working as a civil engineer. 20 years reading surveys, easement agreements, drainage plans, and property boundary documents with the kind of focused attention that most people save for things they actually enjoy. So when I took over the property, I didn't just flip through the paperwork. I went through every single piece of it. I found the original deed rolled in a cardboard tube inside a fireproof cabinet in the back room. I unrolled it on my kitchen table, read every line twice, and then put it somewhere considerably more secure. The 11 cabins Chester's family had built over the years were simple, solid structures, screened porches, propane heat, positioned along the water's edge. I leased 8 of them each summer on short-term agreements to families who wanted a quiet week near the lake. Nothing complicated. Nothing extravagant. The lease income covered taxes, maintenance, and a small reserve. That was the whole arrangement. But there was one clause in every single one of those lease agreements, something my attorney Patricia had insisted on from the very beginning of our working relationship. The clause stated that the tenant was permitted to use Mercer Private Road for entry and exit during their lease term by explicit permission of the property owner. When Patricia first recommended that language, she said only that it was the kind of clause that could matter someday. I didn't ask her to elaborate. I just made sure it was in every contract, every time, without exception. I didn't fully understand why yet. I would. In 2019, a man named Gerald purchased 18 acres of land directly north of my property. I didn't think much of it at first. Land around Clearwater Lake changed hands occasionally. New neighbors weren't unusual. What I didn't yet understand was what Gerald had spent the better part of 2 decades in Nashville real estate getting very, very good at. Not developing land, not building things. Constructing frameworks of authority on paper that looked completely legitimate from the outside while resting on absolutely no legal foundation underneath. Within weeks of his purchase, he filed incorporation papers for what he called the Kellerton Lake Owners Association. He appointed himself president. He placed 3 partners on the board, a real estate attorney, an accountant, and a general contractor, and began distributing membership invitations to property owners throughout the lake area. The letter I received was friendly enough. The attached community standards code was something else entirely. It granted this brand new organization authority to manage, and I want you to notice how elastic this language is. Access points to the lake area, a phrase stretchy enough to mean almost anything. And included with the materials was a map that showed the gravel road running through my property, labeled as Access Road A, Community Easement, Known Owner. No government seal on the document. No county signature. Not one line of that entire package carried the stamp of any governmental body anywhere. I declined the invitation in writing. Then I drove out to County Road 7, rested my hand on Chester's old concrete marker for a moment, and drove home. I pulled the deed from the safe, confirmed what I already knew, and locked it back up. Someone had just drawn a map that included my road without my permission. And in my experience, people who do things like that rarely stop at maps. Gerald was not a man who paused once he sensed an opening. By early 2020, the organization had stopped sending invitations and started sending directives. Gerald understood the psychology of that distinction perfectly. An invitation acknowledges that you have a choice. A directive assumes you don't. And he applied it with the calm confidence of someone who had run this same sequence before in other counties with other property owners and watched it work every time. The first move was the signs. 3 identical boards appeared along my gravel road one Tuesday morning in March, installed without notice, without a permit, without any communication to me whatsoever. Each one carried the organization's logo and a single line of text, Kellerton Lake Community Road, managed by KLA. I found them on a routine visit to the property. I photographed every single one from multiple angles, recorded the GPS coordinates, noted the date, and left every sign exactly where it had been placed. Taking them down myself would have been the instinctive reaction. Instinctive reactions in situations like this tend to benefit the other side. I wanted a documented record of what they had done, not a documented record of what I had done in response. Next came the map. A private commercial mapping firm, not a licensed county surveyor, not any office with governmental authority, produced what the organization called a community area map of the Clearwater Lake region, full color, professionally printed, distributed at community meetings, and attached to every piece of official-looking correspondence going forward. On that map, my road appeared as a community easement, rendered with the same visual confidence as every other labeled feature, as though its legal status had been formally established rather than quietly invented by people who had never once opened the county deed index. Then came the agreement, titled an Infrastructure Sharing and Community Access Agreement, described in the cover letter as a routine administrative formality. Read carefully, the definition section covered my gravel road under the umbrella of community infrastructure. The signing deadline was underlined. Non-compliance could result in reclassification of access status, whatever that meant. I read it twice, added it to my folder, and did not respond. Then came the fines. In April of 2020, I received a formal notice of community standards violation. The infraction, failure to maintain landscaping consistent with the community code. The community code I had never signed, never agreed to, and had no legal obligation whatsoever to follow. The invoice came to $850. By June, a second notice arrived with a running balance and new charges, now totaling $2,100, with a note about potential legal proceedings. What Gerald had perfected over his career was the weaponization of institutional appearance, official-looking letterhead, a running dollar amount, a deadline. Those 3 things alone were enough to make most recipients feel cornered. They didn't stop to ask whether the organization actually had any authority over them. They felt the weight of it, and they folded, not because they had been legally defeated, because they had been made to feel isolated and confused by someone projecting absolute certainty. Meanwhile, posts started appearing in the lake area's online community forum, carefully worded to avoid naming me directly while leaving no real ambiguity about the target. One questioned why the southern access road was being neglected by a property owner who refused to participate in shared upkeep. Another raised concerns about commercial licensing for the rental cabins in the area. A third expressed disappointment that a single landowner's refusal to cooperate was holding back progress for the whole community. None of the accounts posting those items identified themselves as affiliated with the organization. They didn't need to. I captured every post, logged dates and account names, forwarded everything to Patricia, who by this point had quietly begun assembling a case file on my behalf. I had called her early in the process with one specific question: what exactly can a private landowner do with a road they own outright when someone attempts to use it without authorization? Her answer took 15 minutes and covered prescriptive easement law, trespass liability, and the specific documentation requirements under Tennessee property statute. When she finished, I understood two things completely: what Gerald was attempting and exactly why it was going to fail. I just needed him to keep going long enough to make the failure total and undeniable. Now, here's where it gets interesting. In March of 2021, the excavators arrived. I heard them before I saw anything, a low mechanical groan carrying across the tree line from the north side of the lake, the kind of industrial sound that doesn't belong to that landscape. Gerald had secured his building permit for what he was calling Clearwater Retreat Phase 1. 11 luxury cabins with outdoor soaking tubs, floor-to-ceiling lakeview windows, and imported hardwood interiors. An infinity pool positioned to catch the sunset reflection off the water. A lakeside dining space with a commercial kitchen. Paved parking for 30 vehicles. Construction budget, $2.1 million. Target opening date, Memorial Day weekend 2022. He had already started taking reservations. Every cabin was booked for that first long weekend at rates that put projected revenue for just those 3 days alone at $48,000. And every single delivery truck, every concrete mixer, every flatbed carrying steel framing and prefabricated window units, all of it came down County Road 7, past Chester's rust-marked stake, onto my gravel road and straight through to the build site, 6 days a week. 7 in the morning until 5 in the afternoon. For months. No phone call. No written request. No acknowledgement in any form that the road their entire operation depended on belonged to someone who had given them no permission to use it. I documented everything. Timestamps on photographs, notes on vehicle types and frequency, measurements of the shoulder damage accumulating where heavy loads were compressing the drainage margins and pushing the gravel outward. Midway through the summer, I hired an independent traffic engineer to conduct a formal site assessment. His written report identified 7 developing road depressions, 3 locations where the original drainage infrastructure had been structurally compromised, and average shoulder subsidence of 4 to 6 centimeters along the full length of the road. He estimated the restoration cost at $38,000. I filed his report alongside everything else. Then, in May of 2021, a formal letter arrived from their attorney. The document was titled A Historical Easement Notice. The central argument was that the road had been used openly and continuously by members of the surrounding community for more than 20 years, thereby establishing what Tennessee law calls a prescriptive easement, a right of use acquired through long, uninterrupted, unauthorized practice. The letter was written with enough legal vocabulary to sound credible to anyone unfamiliar with how prescriptive easement law actually works. That was the entire bet. The problem with the argument, as Patricia had explained to me months earlier, was categorical. Prescriptive easement under Tennessee statute requires that the use be hostile, meaning without the landowner's permission. Every single person who had ever driven that road had done so as a tenant under a signed lease containing explicit language granting them access by my authorization. Permitted use cannot ripen into a prescriptive easement. The legal theory they were deploying required precisely the condition that my lease contracts, clause by clause, had eliminated for over a decade. I forwarded the letter to Patricia. Her response came back in 4 words: "They are bluffing badly." In September of 2021, Gerald filed a civil lawsuit in Kellerton County Civil Court. He sought judicial recognition of a prescriptive easement and demanded $15,000 in damages for what he called my obstruction of community access. It was his most aggressive move yet. It was also, without him knowing it, exactly what I had been waiting for. Because once a lawsuit is filed, every document goes into the record. Theirs and mine both. Patricia had built her career on one operating principle. She preferred to win before walking into a courtroom by making the other side understand they had already lost. When she looked at their complaint, she set it down and said very calmly, "They just gave us the venue we needed. Now we finish building what goes inside it." What she had been assembling quietly for months was not simply a defense. It was a counter-architecture designed to dismantle their position at every structural point simultaneously. The first step was verification at the county level. Patricia submitted a formal records request to the Kellerton County Land Records Office asking for the complete ownership and encumbrance history of the parcel from 1961 to the present. The response confirmed what the original deed had always stated. Chester purchased the parcel in its entirety in 1961. The road was included within the boundary description. No easement of any kind, express, implied, or prescriptive, had ever been recorded against it by any party. It had never been transferred to the county road system. It had never appeared on any public infrastructure map maintained by any governmental body. It was, in the language of the records office, an unencumbered private road in continuous single-family ownership since the date of original purchase. That document alone ended their primary legal claim. But Patricia was not building for minimum sufficiency. She was building for complete collapse. She pulled every lease agreement I had executed since 2009. Every single one contained the same clause. She arranged them chronologically, flagged the relevant language in each, and attached them as a unified exhibit. The argument was not complicated once the documents were laid side by side. Permitted use does not create a prescriptive right. Every documented use of the road had been authorized. Their foundational legal theory had been contradicted by my own paperwork before they ever filed their complaint. The traffic engineer's report and photographs went in as a standalone exhibit, paired with a timeline showing exactly when the construction vehicles had started using the road and cross-referenced against the dates they had filed their building permit and broken ground. The sequence was unambiguous. Patricia also drafted 3 separate formal complaints. One to the County Land Records Office, flagging their community map as a document that materially misrepresented recorded property boundaries. One to the County Building Commission, requesting a review of whether the construction permit application had accurately disclosed the legal status of the road it designated as the project's primary access route. And one to the Tennessee Board of Professional Responsibility, the body that oversees attorney conduct, citing their lawyers' preparation and transmission of a legal demand letter asserting easement rights that the underlying records directly and unambiguously contradicted. The counterclaim listed 4 causes of action: trespass, defamation, fraudulent misrepresentation, and damages totaling $90,000. None of this was filed with urgency or announcement. No press releases, no forum posts, no angry letters to the newspaper. Gerald received copies through his attorney as required by law, and for 5 months, between September of 2021 and February of 2022, he kept building. Crews kept working. He kept posting updates about the upcoming opening. The reservation calendar kept filling. He was still operating as though the outcome had already been decided in his favor. He had not yet understood what was in the file Patricia had spent 2 years building, and I saw no reason to explain it to him before the moment it would matter most. By March of 2022, Clearwater Retreat was entering its final construction phase. From County Road 7, you could see the roof lines through the tree line. Clean angles, dark timber cladding, large glass panels catching the afternoon light off the lake. The infinity pool had been filled for leak testing. The commercial kitchen was installed and running. The parking area graded, sealed, and striped. Whatever else you could say about the project, it had been built with care and with real money. The The final cost had exceeded the original budget, $2.6 million total against the $2.1 million projected at groundbreaking. Gerald had covered the gap by bringing in 7 additional investors, each contributing between $80,000 and $200,000 on the strength of his revenue forecasts. Every cabin was booked solid for Memorial Day weekend. Projected revenue for that single 3-day window, $48,000. Gerald had a ribbon-cutting ceremony arranged with local officials, press materials sent to the paper, a private investor dinner reserved for opening night. He had done everything a developer does when he's certain the hard part is behind him. What he had not done was verify the legal status of the road his entire operation depended on. Here's why that failure happened. First, he had treated the community map as though the act of producing it professionally had conferred the rights it depicted. He never checked whether any easement over the road had actually been recorded with the county. Second, when his permit application listed the road as the project's primary access route, he described it as an established community access road without attaching any supporting easement documentation, and the County Building Commission had processed the application without independently verifying that claim. Third, and maybe most importantly, he had spent 2 years watching me ignore his fines, decline his invitations, and say nothing publicly. And he had read that silence as weakness. He had never once considered the alternative explanation. On May 15th, I had a professional signage company install a formal notice board at the road entrance, right next to Chester's old concrete marker. White background, Initing Archer as black lettering, weather sealed. It read, Private property, Mercer, private road. All vehicle access requires written authorization from the property owner of record. Patricia's office phone number, the deed parcel number, a statement of existing fact posted on private land in plain language that any adult could read. Gerald's crew passed it every morning for 4 days without stopping. At 6 o'clock on the morning of May 19, 2022, I pulled off County Road 7 and parked on the shoulder. The sun hadn't fully cleared the eastern ridge. The air smelled like pine resin and damp soil. 4 people were waiting. 2 fence installers with a post driver on a flatbed, a licensed land surveyor who had confirmed the installation coordinates against the recorded deed boundary the previous afternoon, and Patricia, who had driven up from Nashville the night before and was standing at the entrance with a document folder under her arm and a thermos of coffee in her hand. The installation took 90 minutes. 2 steel posts set in poured concrete footings on either side of the road entrance, precisely within the boundary of my parcel as confirmed by the surveyor's equipment. A heavy tubular gate spanning the full width of the road, secured with a commercial grade lock. A steel sign, powder-coated white with raised black lettering that would not fade or peel. It read, Mercer Private Road, no access without written easement agreement. Property of D. Mercer, owner of record, deed parcel C441B, Kellerton County Land Records. While the concrete was still curing, Patricia drove to the courthouse and filed 3 documents simultaneously. The complete counterclaim package with every exhibit, an emergency motion for a temporary restraining order barring anyone affiliated with the organization from accessing or directing traffic across my road pending resolution of the ownership dispute, and a written notification to the Kellerton County Fire Marshal's office advising that the road scheduled for inclusion in the May 20th pre-occupancy inspection of Clearwater Retreat was currently subject to active litigation, had been gated by the owner of record, and could not be represented as an unobstructed access route for the purposes of fire safety certification. Because here's what Patricia and I had known since February. In Tennessee, any commercial lodging facility must receive fire safety clearance before accepting overnight guests. That inspection checklist required confirmation that emergency vehicle access to the property was unobstructed and of sufficient width to accommodate fire apparatus. Without clearance from the fire marshal, there was no opening day. The inspection was the dependency that Gerald had never thought to protect. Gerald arrived at the site at 8:30 that morning. A delivery truck was already backed up on County Road 7, unable to enter. He walked to the gate, read the sign twice, and called his attorney. That conversation, as the attorney later described in a sworn deposition, lasted 11 minutes. The attorney told him the gate was on private property and could not be removed without exposing them to criminal trespass liability. He told him the counterclaim Patricia had just filed was not a negotiating document. It was a comprehensive factual record supported by original county instruments that predated their entire project. And he told Gerald, in the careful language of an attorney who had just read something that alarmed him, that the prescriptive easement argument they had built their lawsuit on had been structurally eliminated by the lease documentation and that he did not see a path to winning the underlying claim. Gerald asked him what they should do. The attorney said he didn't have a good answer to that question. At 10 o'clock, 3 vehicles from the Kellerton County Fire Marshal's office arrived on County Road 7. The lead inspector got out, examined the gate, read the signage, and made a phone call back to his office. The call lasted 4 minutes. When he ended it, he walked back to his vehicle and told his colleagues the inspection could not proceed. The designated access route to the facility was gated by its legal owner under active dispute, and the office had received formal written notification of that status that same morning. Without confirmed, unobstructed access for emergency apparatus, pre-occupancy clearance could not be issued. Clearwater Retreat could not open to guests until the matter was resolved through the appropriate legal channels. The 3 fire marshal vehicles turned around and drove back toward town. By 11:30 that morning, one of the 7 investors, a man who had asked Gerald a direct question about road ownership 2 months earlier and received a dismissive answer, was on the phone demanding a written explanation of what had just happened to his $150,000. By early afternoon, all 7 investors had been notified and were in contact with their own attorneys. I sat in my truck on County Road 7 for a while that afternoon, parked far enough back that I wasn't in anyone's way. Through the tree line, I could see the roof lines of the Clearwater Retreat cabins catching the last of the afternoon light. Finished, furnished, completely inaccessible. On my side of the gate, Chester's old concrete marker stood in the weeds where it had always stood. I drove home without saying anything to anyone. The unraveling that began on May 20th did not stop for months. The first investor filed his individual lawsuit before noon that day, alleging fraudulent misrepresentation in the solicitation of his investment. By the following afternoon, the remaining 6 had signed onto a joint action, making the same argument, with combined damages sought totaling $910,000. The attorney they retained had handled commercial fraud litigation for 30 years and had a reputation for taking cases to verdict rather than settling. Gerald called his bank. That call did not go the way he needed. The construction lender had extended a loan of $1.2 million against the projected operating revenue of the retreat and had already been monitoring the situation through public court filings. A loan officer contacted Gerald directly within 2 days to advise that under the terms of the lending agreement, any material change in the legal accessibility of the collateral property triggered a review clause. Gerald was given 30 days to provide documentation confirming unencumbered access to the facility. If he could not provide it, the loan would be reclassified as in default. He could not provide it. The documentation did not exist. It had never existed. The County Building Commission completed its review of the permit application in late May. The commission found that the application had represented the road as an established community access route without providing any recorded easement documentation to support that characterization. The permit was placed in administrative suspension pending resolution of the underlying property dispute in civil court. The Tennessee Board of Professional Responsibility opened its formal inquiry into the attorney in early June, citing 2 specific concerns: that he had drafted and transmitted a legal demand letter asserting easement rights that the county deed records directly and unambiguously contradicted, and that he had been involved in producing and distributing a community map that misrepresented recorded property boundaries and had subsequently been used as supporting documentation in official permit applications. his estimated cost of representation before the board between $80,000 and $120,000. A court order freezing the organization's operating accounts was granted in mid-June pending discovery. That freeze affected not only the Clearwater retreat funds, but also the dues collected from the 23 other property owners who had joined as ordinary members, whose money had been commingled in the same accounts. Those members received notification letters from the court administrator explaining that their funds were subject to the hold. The wave of resignation letters and public complaints directed at the organization from its own membership was, by any measure, a final structural failure it did not recover from. The general contractor, who had built the entire retreat and had not yet received his final payment installment of $340,000, filed a contractor's lien against the property and initiated his own legal action for breach of contract. He was a creditor now, standing in line behind the bank, the investors, and the county. 11 finished cabins. A pool. A restaurant. A parking area. Sitting idle through the entire summer of 2022, generating no revenue, accumulating carrying costs, declining in effective value with every passing week. Gerald's total personal financial exposure by the end of that summer, the full construction cost he couldn't recover, $910,000 from the investors, $1.2 million moving toward bank default, legal fees across multiple concurrent proceedings estimated to exceed $200,000 before any of the cases reached resolution. It was not a number a man rebuilds from easily, and Gerald knew it. My 11 cabins had their usual summer. Families came and went on their lease agreements. The gravel road carried the traffic it had always carried. People there with permission, moving at reasonable speeds, leaving the surface more or less as they'd found it. The civil trial opened in Kellerton County Civil Court in September of 2022. The judge had 22 years on the bench and a particular clarity of manner when the documentary record in a case was unambiguous. She had reviewed the file before the first session. During the opening day of proceedings, she directed most of her substantive questions not at Patricia, but at their attorney, who was still representing the organization despite the professional responsibility inquiry pending against him. Her questions were precise and not especially gentle. She asked him to identify any recorded instrument establishing an easement over my road in favor of any party other than my family. He could not produce one. She asked him to explain the legal basis for characterizing the road as a community easement in documents submitted to the County Building Commission, given that no such easement appeared anywhere in the county records. His answer was long and did not satisfy her. The trial lasted 3 days. On the 4th day, the judge issued her ruling from the bench. Mercer Private Road, as described in the deed recorded with the Kellerton County Land Records Office in 1961, was the unencumbered private property of my family. No express easement had ever been granted. No implied easement arose from the circumstances of use. And the prescriptive easement theory, the entire foundation of their lawsuit, was defeated entirely by the lease documentation, which established that every recorded use of the road during the relevant period had occurred with the explicit permission of the property owner. Permitted use, the judge noted in language that left no room for reinterpretation, does not ripen into prescriptive right under Tennessee law. Their complaint was dismissed with prejudice. On the counterclaim, the judge awarded damages in 4 categories: $38,000 for physical road restoration based on the traffic engineer's assessment, $25,000 for reputational harm based on the pattern of coordinated false statements, $12,000 in legal fees, and $15,000 in punitive damages for willful trespass. The court's finding that the organization had knowingly directed construction traffic across private land without authorization, and that characterizing that road as community property in public documents had not been an innocent error, Total judgment against the organization and Gerald jointly $90,000. The attorney's law license was suspended for 18 months. The County Building Commission issued a formal policy clarification requiring that all permit applications involving private road access include recorded easement documentation before approval. Gerald was separately referred to the County District Attorney's Office for review of potential criminal liability. He filed for personal bankruptcy in November of 2022, with total declared liabilities exceeding $4.9 million. Clearwater Retreat went into receivership and sold at auction in March of 2023 for $1.1 million, less than half of what had been spent to build it. The Nashville-based firm that purchased it contacted Patricia's office about a formal long-term easement agreement for road access. She negotiated it on my behalf. Annual access fee. Clearly structured maintenance responsibilities, written notice requirements, full documentation filed with the county records office. Exactly the kind of arrangement that would have cost Gerald almost nothing if he had simply sought it honestly at the beginning. Instead, it cost him everything he had built. I drove out to the property on an afternoon in October after the judgment had been entered and before the leaves had fully turned. The gate was gone. It had served its purpose, and I saw no reason to leave it standing once the court had established what needed to be established. Chester's old concrete marker was still there at the entrance, rust-red paint and worn letters standing in the same weeds it had occupied for 60 years. I sat with the engine off for a few minutes, listening to the pines move in the wind off the lake. My grandfather had told my father never to sell the road. My father had passed that instruction to me without fully knowing what it meant. I thought I understood it when I inherited the property. I understood it completely now. Chester hadn't been protecting a road. He had been protecting a principle that what you own, you document. That what you document, you defend. And that the moment you stop paying attention to the details is the moment someone else starts writing them for you. 4 things worth taking from this story. Know exactly what you own. Not approximately. Not based on what someone told you at a community meeting. Pull the deed. Read every line. Chester documented that road correctly in 1961, 6 decades before it mattered. That single act of precision was the foundation of everything that followed. Organized pressure is designed to make resistance feel more costly than compliance. The counter is never anger and never a public argument. It is documentation. Every notice, every fine, every threatening letter goes into a file. You respond legally, in the correct venue, at the correct time, with the correct instruments. The man in this story didn't win because he was louder. He won because he was quieter, longer, and better prepared. Timing is a weapon. There is a moment in every dispute when the other side becomes fully committed. Investors in, loans drawn, opening date on the brochure. That is the moment of maximum leverage for the person holding the document the other side never bothered to check. And finally, legal rights don't enforce themselves. A deed locked in a safe protects nothing until someone is willing to carry it into the process and use it. 2 years of silence was not absence, it was preparation. Chester told his son never to sell the road. He never explained why. He didn't need to. He had already put the reason in writing in a county records office where it waited 60 years for the moment it was needed. That is the only kind of protection that holds. If this story made you think about something you own, something you've been overlooking, something worth going back and reading carefully, that's exactly the point. Hit like if it got to you. Subscribe if you want more stories like this one, because there are a lot of them. The people who pay attention to the fine print don't always make the headlines, but they always outlast the ones who don't. I'll see you in the next one.